Good evening, friends, and thank you for being with us tonight. Welcome to the Daniel Webster Debate Series, hosted by the Georgetown Law Federalist Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is regularly remembered as the great expounder and defender of the Constitution. Our resolution tonight is do DEI programs violate equal protection? Maybe in the news today and these past couple weeks, so a timely debate for sure. To debate this important topic, we have Constable McCarthy's own Katie Lane, who also served as the former Deputy Solicitor General for the state of Montana, and Professor Susan Carl of the excellent American University Washington College of Law. We're also thrilled to have the Honorable Judge Joshua Wolfson of the United States District Court for the Eastern District of Pennsylvania as our esteemed moderator. We are deeply grateful to the Federal Society and to Georgetown Law to make the Daniel Webster Debate Series a reality. I now recognize our wonderful Director of Events, Dennis Azwolinski, to introduce these three stellar panelists. Please give them a warm welcome.
Thank you, Brady. And I want to recognize our wonderful president, Brady Morrison, who made our chapter of the year again. So yeah, I'm going to keep saying that. So the Honorable Joshua D. Walton serves as District Judge of the United States District Court for the Eastern District of Pennsylvania, having received this commission to join the bench in May of 2019. Prior to taking his seat on the bench, Judge Wilson was a partner in the litigation group of Dilworth Paxton LLP, where he practiced since 2008. While there, he served as a co-chair of the firm's Plaintiff's Rights Practice Group and a member of the firm's executive committee. Before joining the firm, Judge Wilson practiced in the litigation and antitrust groups of Covington and Burling in Washington, D.C. Upon graduation from law school, Judge Wilson served as a law clerk to Judge Jan E. Dubois of the U.S. District Court for the Eastern District of Pennsylvania. Did I pronounce Dubois right? Dubois, sorry. Judge Wilson earned his B.A. magna cum laude from the University of Pennsylvania and his J.D. cum laude from the Harvard Law School. Katie S. Lane is also joining us today. She's an associate at Constable McCarthy, PLLC, where she assists clients with a variety of litigation and appellate matters that encompasses constitutional law and administrative law. Prior to joining the firm, Ms. Lane served as Deputy Solicitor General for the state of Montana, where she worked on civil trial and appellate matters in both state and federal courts. Before that, she was an associate at a large law firm in D.C. Ms. Lane is a former law clerk to Judge Timothy Timkovich of the U.S. Court of Appeals for the 10th Circuit and Judge Thomas Farland of the U.S. District Court for the Eastern District of Tennessee. She served as a law clerk for Senator Ted Cruz on the Senate Committee on the Judiciary during Justice Neil Gorsuch's confirmation hearing. She earned her J.D. magna cum laude from the Antonin Scalia Law School at George Mason and her B.A. magna cum laude from Furman University. Thanks for joining us today. And now we have Professor Susan Carl, who is a professor of law at the American University Washington College of Law, where she teaches and writes about civil rights, legal history, employment discrimination, labor and employment law, legal ethics, and the history and sociology of the legal profession. She has served as Washington College of Law's first Associate Dean for Scholarship and as chair of the American Associate of Law School section on Professional Responsibility and Professional Development Committee. Professor Carl attended Yale Law School, where she served as the editor of the Yale Law Journal. After graduation, she clerked on the United States Court of Appeals for the Third Circuit, and then worked as an appellate attorney in the Civil Rights Division of the U.S. Department of Justice under George H.W. Bush, where she met Chief Justice John Roberts. At the leading union side labor and employment law firm at Brethoff and Kaiser. Professor Carl was W.M. Keck Fellow in Legal Ethics at Georgetown University Law Center from 1995 to 1997. So welcome back, Professor, and another round of applause for our wonderful speakers. I'm excited to hear about it.
All right, well, let me kick things off and say thank you for having me here. I appreciate it. As you heard, I started my career in Washington. I lived here for about 8 years, so it's always fun for me to get to come back down. I've also made some folks back in Philly a little jealous today, but my wife, who I met here, and also my current law clerk, who is a recent Georgetown University Law Center graduate, who would have loved the opportunity to come with me. I'm actually 3 for 4. 3 of my last 4 years, I've had Georgetown law grads as law clerks. So it's always nice to come back. I'm interested to have this topic here tonight. You've seen the resolution. It's do DEI programs violate equal protection? I won't say it's the most topical thing, but it's right about at the top of the list of the most topical things that we could be talking about. So it's great to have the opportunity to have a really interesting, thorough discussion about this question. I want to give a few thoughts about this just as an introduction before I turn it over to the panelists who have way more substantive knowledge than I do on these topics. But let me start with this. I don't know if anyone here, I'm going to assume, because it's a top flight law school, that some people here were collegiate debaters. Yes? Yes? Few nods, yes, okay. So when I was a collegiate debater back when I did APTA, that was a long time ago when my hair was dark and I didn't have kids. I learned that one of the things you start with is to look at the case statement and focus in on the terms in the case statement, right? So that's what I want to do here with my introductory remarks, because there's really two things that jump out at me from the case statement that I think should tee us up and focus our attention as to what we're going to talk about here tonight. And so the first of those is the phrase equal protection, and the second is DEI. So let me start with that second one first, DEI, because one of the things we all need to think about and that we should have a discussion about as we have this conversation tonight is what exactly are we talking about when we talk about DEI? It can be thrown around as an all-consuming term. It can be thrown around as a very narrowly focused term. It is actually, I mean, on its face, an amalgam, right? I mean, I study text for a living. I analyze text for a living. It is, from a textual standpoint, an amalgam of three separate words, right? And they are, although they have been smushed together, that's the technical legal term, they are really three somewhat separate concepts. And so we have to think about that as we talk about this tonight. So when we talk about diversity, are we talking about increasing representation of underrepresented groups? If so, we have to think about who defines what it means to be underrepresented so that we can then decide that. I was thinking about this today. I was reminded of Lisa Simpson saying to her father, if you're the police, who's going to police the police? His answer to that was the Coast Guard. It's an interesting question. Who's going to resolve these definitional questions if we're going that route? And again, one of the questions that will then come up is at what level of specificity do we define these things? One of the other hats I wear is I have to apply the law of qualified immunity. You may all have had a debate about that at some point this year or in the last couple of years. It's an interesting topic. The degree of specificity at which you define something often determines the outcome. So if we're talking about this in the concept of diversity, are we talking about single classifications? Are we talking about intersectional classifications? Do we only care that we are promoting, women, blacks, Muslims? Do we care about promoting black Muslims or Muslim women? These intersectional combinations can raise thorny questions as well. The second term here, equity. Are we talking about equality of opportunity? We're talking about equality of result. Those can lead to very different policy prescriptions. They can lead to potentially different legal outcomes as well. And those are questions that we need to grapple with and to understand if we're going to have a meaningful debate about the topic. And, finally, when we talk about inclusion, again, what does that mean? That ties back in some respects to the same equality of opportunity, equality of result question. Is it outcome determinative? Are we only focused on outcomes? Are we focused on motive? What are we doing here? Those are some of the important questions that I think you have to grapple with as you think about defining what DEI really is. Then we turn to the other term in the case statement that I think is worthy of pausing on, and that is equal protection. Equal protection is, of course, a constitutional mandate, right? So what does that mean? Well, first and foremost, it means that what we're really talking about here tonight is the government. That doesn't mean we can't lead into discussions about some of the statutes that apply in this area as well. Title VII, Title VI, Title IX. These are all things that have been the subject of significant parts of litigation relating to these issues writ large. But when we talk equal protection, really what we're talking about is the government. And so we step back, we think about where this comes from. What is equal protection? Where does equal protection emanate from? It emanates from Section 1 of the 14th Amendment, right, which says that no state shall deny to any person within its jurisdiction the equal protection of the laws. and that applies by its terms to the states. Supreme Court says that the concept of equal protection also applies to the federal government through the due process clause of the Fifth Amendment. And then we think about, well, what is equal protection as a concept? What are we really talking about here? And, we can go back in time about 40 to 50 years. The Supreme Court says that equal protection is essentially a direction that all persons similarly situated should be treated alike. That's the City of Cleburne versus Cleburne Living Center. It sounds like an easy, simplistic statement. I love easy, simplistic statements until you get into the details and have to apply them, and then it becomes really challenging. And so implementing that directive is not so easy, and courts have struggled with it ever since the pronouncement was made, and they continue to do so. And we continue to see the evolution of this, and courts grappling with how to apply this concept as policymakers deal with questions of equality and equality of opportunity versus equality of result. And so many policymakers look to remedy what they see as societal wrongs, whether they're historical or otherwise, versus running up against these constitutional concepts. Almost 20 years ago, Chief Justice Roberts, in Parents Involved in Community Schools case, wrote, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. That didn't necessarily happen as a legal doctrine. Certainly, we were also living in a world of Rutter and Gratz at the same time, at least in the university admissions case. More recently, we have the SFFA cases that the Supreme Court decided 2 years ago. But courts continue to grapple with what the implications of that means, both for college campuses, other educational settings, and certainly outside of the educational settings as well. And so when we think about this, the contexts in which this arises, there's really, I would say, 3 that jump out at me as the most common situations in which the government has attempted to remedy some societal ill, policymakers have attempted to remedy some societal ill by looking at these classifications, right? There's school admissions, and that can be, in the college and university setting, like the SFFA cases, like Rutter, like Gratz. There's also questions about primary and secondary education in situations like charter schools, which are public entities, maybe, and then certainly magnet schools as well. And so that poses challenges of their own right in the primary and secondary education space. This has obviously been a series of long-running cases culminating with SFFA. There's the government employment space, and this includes hiring and promotions and training. Particularly, the trainings have been the source of a series of questions and cases about what constitutes a hostile work environment. And do DEI trainings somehow create an environment in which people should not be forced to work? Those are cases that are often pending. Many of them are still pending today as we see here. And then the third area where this comes up is government contracting. For those who have never waded into the world of government contracts, I can tell you, as someone who did some public procurement work in private practice, that most government or many government contracts have as a component some sort of diversity score that is a thumb on the scale of the public bidding. They often require a small diverse business component, and depending how much work you are willing to commit to that small and diverse business, your score may go up, and you stand a better chance of winning the bid. Is the government allowed to do that? What are the policy reasons for which they do that? And so we step back and we think about the legal framework in which all this comes up. And, I'll provide this really quickly and then we'll get into it more. But, we're talking about constitutional rules here. So we're tend to veer often into levels of scrutiny and how they apply. When you have classifications of race by race and religion and national origin, you're probably talking about strict scrutiny. When you have classifications by gender and maybe by sexual orientation, particularly given what the Supreme Court said in Bostock, you're probably talking about intermediate scrutiny. Other classifications that maybe get used by policymakers, socioeconomic status, and things like that, are probably subject to rational basis review. But we can talk about that too, and whether they should be and whether they are. Another question we have to ask is intent, right? And so when we talk about DEI, if the purpose is diversity, if that is the end, does that look different than the question of what if you're doing it for another reason, right? And so in the employment context, we talk about this as disparate treatment versus disparate impact. And do those concepts matter when we're talking about this in the context of equal protection? And if so, how should we think about them? And I'll tee up just a couple quick examples, and then we can get into those discussions later. But you can imagine, for example, a city that says we are hiring a police force and we are emphasizing diversity, not because we care about diversity as policymakers per se, but because there is empirical evidence that says that having a police force that mirrors the community in which they operate leads to better outcomes. Or the same could be said for a prosecutor's office that says that we have empirical evidence that says that by hiring lawyers who mirror the jury pool in which they appear, in front of which they appear, we get a better conviction rate. Is that allowed? Is that a DEI problem? Is that even DEI? Right? These are some questions that I think we should have to grapple with as we go today. And so there's several constitutional tensions for us to talk about. Does equal protection require absolute race neutrality? Does it leave some wiggle room, some room in the joints, as sometimes is said in some of these cases? Is there a way to design a DEI initiative that doesn't run afoul of the protection clause? When courts consider challenges to DEI programs, should they be analyzed differently if they address race, religion, and gender, and disability, and age, and socioeconomic status? And are there other constitutional provisions that may be implicated here, like the First Amendment, maybe even the Privileges and Immunities Clause? So those are a lot of the questions that I think can be teed up today. I'm going to turn it over to Katie for some opening comments, and I look forward to an interesting and spirited debate.
Thank you so much. And thank you to the Federalist Society for having me this evening. Obviously, a lot of ground to cover. I'm kind of going to focus my efforts on try to narrow that a bit. So I can appreciate the fact that DEI, as we talked about, covers a lot of ground. And but when I think of DEI in action, what we're seeing in a lot of these cases are race-based programs that are providing benefits to individuals based on race. And so that's kind of where I'm going to focus my opening remarks today, of course, acknowledging that there's a lot more out there. And so I first want to go a little bit into some more detail about discussion about the SFFA decision from the court, and then touch on some of the DEI litigation that my firm is involved in to kind of articulate some real world examples and maybe explain a little bit about how I see students for fair admissions applying in those contexts. So as we've all kind of acknowledged, one of the more recent landmark cases in this space was the Students for Fair Admission, June of 2023. So about 2 years later, obviously still grappling with how this affects other programs outside of the admissions process. And so in that case, I'll just briefly restate that, the court declared that Harvard and UNC's admissions policies that gave preferential treatment to certain races were unconstitutional under the 14th Amendment. And the court reiterated there that these race-based programs must satisfy strict scrutiny, something we just mentioned, that they must further compelling government interests, that the government's use of race must be narrowly tailored to achieve those interests. And so neither university was able to satisfy that burden there. And from that decision, I think we get some really important language that's helpful when we're talking about kind of DEI programs outside of the admissions process. Writing for the majority, Chief Justice Roberts wrote that the government, quote, may never use race as a stereotype. And then he went on to say that the government or any state actor cannot act on the idea that minorities always or even consistently express some characteristic minority viewpoint on any issue. And this type of racial stereotyping, the Chief Justice wrote, can only cause continued hurt and injury. And so in other words, we can't assume characteristics or belief things about people based on their race. And so this is where I think it gets particularly tough for DEI programs, particularly, the ones that we're seeing that are based on race, to survive under the 14th Amendment, because they are doing exactly what the Supreme Court said was prohibited. They're classifying individuals perhaps assuming things about these individuals based on their race and then providing a benefit based on those assumptions. And so, like I said, I want to give you a couple of real world examples. My firm has litigated or is actively litigating. So one kind of area is a number of cases involving medical and nursing students, scholarships available for medical and nursing students that were available only for racial minority groups. And in these cases, my colleagues filed a complaint and the case is nearly immediately settled and agreed not to consider race as a factor in evaluating the scholarship applicants. A couple of other cases, similar, slightly different. One program offered access to an exclusive networking directory that was only offered for individuals of a certain race. Another offered $100,000 signing bonuses for Black physicians only. And again, right after being sued, these programs agreed not to consider race. And then there are a number of challenges to fellowship, internship programs. So ones that are open only to minorities. One was open only to Latinos. One was open to minorities broadly, but it specifically excluded whites and Asians from applying. Again, those were quick to resolution. And then perhaps of interest to all of us in this room are the diversity programs at the law firms that we're seeing. So you may have seen yesterday that the chair of the EEOC sent out a number of letters, I think about 20 letters, requesting more information about law firm diversity programs that potentially may violate Title VII. And so like these are kind of what I see as DEI in action. We see these race-based programs and they're prevalent. Obviously, I highlighted some in the medical profession, they're in the legal profession, but I think that we see these more broadly. And so going back to kind of the strict scrutiny framework that we talked about, none of these cases, the defendant or the program administrator even attempt to try to explain what was the compelling interest there, nor would they have been able to show how the programs were narrowly tailored. Like I said, I think all of them, there were only 2 cases that even proceeded to a preliminary injunction hearing, and those were pretty quick resolutions. And so why is that? It's because these programs are not aimed at remedying a specific past harm perpetuated by these specific defendants. Instead, they're generalized programs based on assumptions about large groups of people because of their race rather than individual circumstances. And so after Students for Fair Admissions, I'd say that there's not a strong argument to be made that there is a compelling interest in any sort of program like this that offers a benefit to somebody based on their race alone. And so even if they were able to articulate a compelling government interest, we still have the narrowly tailored aspect, which is even, I think, trickier for these programs. And so all of this, I think, goes back to what we already talked about with Chief Justice Roberts, who said the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And so while I think that DEI programs do have a commendable goal, when they offer benefits to individuals based solely on race or these other characteristics, they're making assumptions about those individuals, which just perpetuates race consciousness and divisiveness in like the workforce, education, et cetera. And so I guess to quickly sum up my thoughts on this, we know for a fact that racial discrimination, racial classifications, racial stereotyping prohibited under the 14th Amendment. I would argue that DEI amounts to racial classification and stereotyping in a lot of the programs as we're seeing them in practice. And since DEI amounts to racial classification, stereotyping, and sometimes blatant discrimination, it violates the 14th Amendment. And as anecdotal evidence of this, I would just point to the fact that no one has really been willing to seriously defend these programs that we're seeing in a court of law. So I'll conclude those remarks and look forward to Professor Carl's.
Thank you all for being here tonight. It's great to see all of you, and it's great to be back at Georgetown. Though the Star Magnolias are still the same. But the buildings, like every time I come here, there's some different kinds of buildings and it's very hard to figure out what's what. But I'm delighted to be here. I think the judge's opening remarks were really terrific. And the point that you really need to define your terms. And I think that's where our differences are going to be. Because I don't think DEI equals racial stereotyping. And if it does, I agree fully with Ms. Banks that that is unconstitutional if it's done by a government actor. You know, some of your examples may have been private institutions, so but that's important. But I want to just start by talking. I'm going to try to set things up and talk a little bit about defining what DEI is and its history as I understand it. So because you are the Federalist Society, and because you and I will share this, and I think everybody in this room will really share the power of this text, I want to start with James Madison, Federalist number 10, if you will indulge me, where he writes about the importance of diversity to society and to the functioning of government. And he points out that different people in any society, and of course he didn't have the more expanded view that we do today, but he still deeply understood that as long as the reason of man continues fallible and he's at liberty to exercise it, different opinions and different views will be formed. And that this is an inseparable obstacle to uniformity of interests. And he says, and that's a really good thing. And then he goes on to talk about his theory of factions and how it's important that the government not end up being controlled by a set of people who all share the same views and the same ideologies. He says it's the nature of man that they are going to have different circumstances in civil society. They're going to have a zeal for different opinions concerning government and attachment to different leaders. They're going to be inflamed in mutual animosity. They are going to have different ideas about religion and about all kinds of other things. And that the sort of one of the durable sources of faction is the unequal distribution of property and privilege in society. I'm adding a little bit of modern language there. And so people are going to be divided into different classes actuated by different sentiments and views. Enlightened statements aren't going to be able to adjust to this, that really what we need is that clash of views, and we need to make sure that we preserve that in our society, that different, people who are different. So that is, if we look at what, I want to just define the sort of the three aspects of what DEI stands for, and then I'll talk about my understanding of where DEI came from, because of my very long career, starting at the Justice Department in a Republican administration and sort of watching what some of the debates were then until today, which is many years later. But so diversity is the state of having a diverse group of participants, as well as policy and norms that are equitable and inclusive. That is the Webster's dictionary definition of what diversity is. It also says that the first known use of the term diversity, equity, and inclusion was in 2001. So it's not a really long-standing thing. And then equity is the quality of being fair and impartial, and inclusion is the practice or policy of providing equal access to opportunities and resources for persons who might otherwise be excluded or marginalized, such as those who have physical or intellectual disabilities and members of other minority groups. So that's where I think we need to start. And then what is done under the name of DEI is a separate question than what does the term actually mean? And I just want to talk a little bit about my understanding of where we ended up, why we ended up in starting in 2001 with the concept of DEI. DEI is an alternative to the concept of affirmative action, right? Affirmative action is a remedial concept. It actually comes from labor law, and it is the concept that if an employer, or often use employer because I teach employment discrimination, but we can talk about education too, where the law is somewhat different, but some of the principles are the same. So the point of affirmative action is if an employer commits a harm, it must take affirmative steps to fix that harm. It's not enough to just say, going forward, I'm not going to I won't do that bad thing anymore. I actually have to try to remedy what I did, right? And so in labor law, that meant reinstating people who had been unlawfully fired or whatever. When we got to the Title VII Civil Rights Act of 1964, it got a little messier because when you went, and you have to remember, this is before most of your time, but at that, in the 60s and 70s, there was blatant discrimination where people of color were cut out of entire parts of the workforce, their good jobs, right? And women were not allowed to have many jobs. And there were, in newspapers, there would be separate pages of advertising for these are jobs for people of color, these are jobs for white people, these are jobs for women, these are jobs for men. So dismantling that took a while. It's dismantled now, but it took a while to do that. And so when employers were found to have committed unlawful discrimination and you try to remedy that, sometimes the people who would benefit from that remedy were not the people who had actually been discriminated against, because those people were long gone for one reason or another. And that was very controversial, right? If you gave a remedy to someone who was not actually a victim of discrimination. And that's where the concern about affirmative action started, right? So I'm not here to defend I agree that sometimes you had to do that, but it was an issue of remedy. And initially these were litigated judgments after finding a liability. Then there came a time, this was my time in the late 80s and before, where employers were realizing it was time to fix things. And they said, look, we want to just go, or they'd be sued, and they didn't want to go fight to litigated judgment because they would agree. We are totally liable. We did these things. We want to fix it. We aren't those kind of people anymore. So we would like to negotiate through a consent decree, usually a court supervised consent decree, some new plan going forward. And the court allowed that kind of voluntary affirmative action, but it was always based on an understanding that there was an acknowledged history of discrimination, right? And then up towards the end of this, there are a couple of cases that suggest where there's a manifest imbalance in the workplace, right? Where the employer is basically saying, we can see, and one of these is a gender case called Johnson v. Santa Clara County, and it's a 14th Amendment case because it's a public employer. And a woman had never been appointed to a certain job in a road crew, right? The supervisor of a road crew. And they gave the woman a little bit of a benefit, and she got that job instead of a male who was pretty much equally qualified. And the court said had never, so it was zero. Manifest imbalance, that kind of affirmative action is acceptable, right? But then that period passed, and it no longer was the case that employers would point to a acknowledged history of blatant discrimination. But they were still concerned because diversity had not really been achieved in their workplaces. They didn't think they were purposely discriminating, but it's hard to change society, and there are all kinds of issues that are getting in the way. And it's at that point that the concept of DEI came up as an alternative to affirmative action. And the people I know who are involved in the DEI field don't think that that race-based programs providing benefits on the basis of race are lawful as DEI, because they're not, right? They're not. But the idea was let's think about other ways that we can work on improving diversity in our workplaces. And many creative ideas were tried. Some of them worked well, some of them didn't work well. But I think we have to start with that understanding that DEI in itself, our president unfortunately does not understand this. I want to talk about it for a minute. But DEI itself is not the problem. It is the way in which some things that are called DEI go too far. And I agree completely that something like granting $100,000 to a Black doctor who's as a signing bonus is if that's a public institution doing that, it's unconstitutional, and if it's a private institution doing that, it's illegal too, under Title VII. So those kinds of things definitely are beyond the pale, and there are, I don't know, employers, I guess, that don't talk to counsel before they invent these things. Morrison and Forrester, which is one of the early law firms that immediately folded when it was shown that they had an internship program that was just for minority students. Those are clearly either illegal or unconstitutional, and they might have done it in the name of DEI, but that doesn't mean that everything that falls under the umbrella of DEI is unconstitutional. So that's the employment picture. Another picture in education, which has really had a very different trajectory. So in the Bakke case, I remember my very beloved professor Drew Days that I took anti-discrimination law from, was one of the litigators in the Bakke case, and he would tell the story about how they were in that case. One of the arguments the plaintiffs wanted to make was that the University of California medical school system had engaged in intentional discrimination and excluded Black students from entering into their medical school program, and that was the basis for affirmative action. And the court rejected that, and so we're not going to assume that. We're not going to go down that road. We're going to say that diversity in the educational experience is the basis for why there's a compelling interest in some attention to race. And of course, then in Grutter and Gratz, the court made it very clear that adding on, giving benefits, giving preferences, adding points, that's Gratz, totally unconstitutional. Taking race into account along with other factors, that's Grutter, that was acceptable. And in Students for Fair Admission, I'm not sure that the court went that far beyond that, actually. And it has this very important paragraph, which it says, and I just re-listened to the oral arguments, which were really great in both the Harvard case, of course, isn't actually a protection case, it's a Title VII. So the court said, as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life through discrimination, inspiration, or otherwise, and it goes on more on that. So the court is saying here, you can't give preferences, can't give add-ons, but when you're considering a human being in this society at this moment, race matters. You know, race matters to how people grew up. Race matters to what somebody's orientation is. It matters to what obstacles they may have overcome as they were coming up. And to the extent somebody wants to discuss that as part of explaining who they are and what their motivations are for going to college or whatever, that's still okay. So I want to just start with that. How much time do I have left? Okay. So the concept of equity, I also just want to talk briefly about that, and I probably won't get, well, that's just a few more things to say, if that's okay. All right. Equity to me has a lot to do with disparate impact analysis, which I've written about. I just want to tell you all, disparate impact analysis was invented. I've written an article on this by Republicans, pro-business Republicans in the state of New York who worked for the National Urban League, who were trying to come up with a best practices business argument about how to open opportunities by examining hiring and employment practices to see if better ones that were more aimed at picking people with the best merit could be used instead of sort of traditional rules that ended up really excluding large numbers of non-traditionally privileged people. And they came up with the disparate impact concept, and then of course the court adopted it, and then Congress put it in the statutory text of Title VII and all of that. But I'm going to give you an example. So let's assume that a building, a business decided, you know, we would save on office space if we only hired small people. So let's just only hire people who weigh 140 pounds or less, right? Because that'll save us room and it will save us rent because we push more people into a room. We would all say that is a ridiculous policy. And it also means that most men will not be able to work for this employer because they're going to be too large, right? And we would have no problem at all in saying that rule should be struck down because it's unreasonable and it is a barrier to opportunity for men. And that's really what disparate impact is about. Looking at the practices that are used for hiring and promotion to see if they are good business practices or if there are other business practices that would achieve better merit-based selection. And that's the kind of thing that I think the equity part of DEI is about. I just want to plead, one of the reasons I wanted to come to you, was that what is going on now around this concept of DEI should be, I think, of concern to everybody in this room. I think you can be a deeply conservative person and still be very concerned that our president is sadly confused about what DEI is, and really in a terrible way. And I know you know this because you were the recipients of this letter recently to say it has come, this is from the acting U.S. attorney for the District of Columbia, who's saying that Georgetown Law School continues to teach and promote DEI, and this is unacceptable. Have you eliminated DEI and from your school and your curriculum? And we want to let you know that we are not going to hire any of your graduates for any fellows program or summer internship or employment in our office. So that is, quite a terrible threat. And I thought your dean was wonderful. I'm sure you've all read the letter that he wrote saying this is a violation of the First Amendment. We, Georgetown, have a right to define our curriculum. And so I just want to point that out. And then finally, I got to tell the Washington Post this, and I was really glad to do it. This notion that the president has been engaged in when there was the crash of the plane at Reagan National Airport. And before any facts were known about who was in the air traffic control tower or who was flying in that plane, he said the crash was caused by DEI. The crash was caused by DEI, as if any non-traditional, if anybody wasn't a white male, was involved in any way in that crash, it was their fault. And as I said to the Washington Post when they called me about that, that is exactly why DEI is still needed. Because those assumptions, the assumption that, of course, a person who doesn't look like your traditional stereotype on the basis of race and gender, right, is therefore incompetent. That is a very terrible thing for a president to be saying at this point in time. And he did it again with the firing of the head of the Joint Chief of Staff, Chairman of the Joint Chiefs of Staff, General C.Q. Brown, happens to be Black, and Hegseth's firing of the Chief of Naval Operations, Admiral Lisa Franchetti, who's female. And what they said, Trump said, Brown was a fine gentleman and an outstanding leader, but DEI, gotta go, right? And Hegseth said the same thing about this woman who was an admiral. If that is what anti-DEI is, then we have to be in favor of DEI, because DEI is what protects everybody from discrimination and the kind of stereotyping that is unconstitutional.
Give maybe a chance for a brief rebuttal if she wants it.
You know what? Let's go ahead and I'll save my thoughts for any questions there.
Okay.
I really appreciate your remarks.
Yes.
Okay. And
All right. So here's what we're gonna do. Because we went a little long, probably because I'm long-winded. And so I have some questions. I'm happy to ask them to the panelists. But if people here have questions, jump in now and take the time while you have us, so that we don't abuse your time. If there's things about the comments that raise questions in your mind, please speak up. Go ahead.
Professor Carl, you made a wonderful point about how often what masquerades as DEI does not fit the traditional definition. At what point, though, does the public conception of DEI and how it's promulgated in these worst case scenarios sort of define what it has become?
right, I think that's a really good point. And I think there's fault in all kinds of directions on that. I think it has been politicized, but I would not argue that there haven't been excesses that are unconstitutional and illegal. And I think some of the examples that were given here are examples of if they're public institutions and they're illegal if they're not public institutions. So I do think it's really important to draw those lines and that we all should be doing that and counseling our clients and counseling our institutions. I don't see it happening in my universe, and I do some consulting with nonprofits and other organizations. But that's because they're talking to counsel and counsel. So
I want to build on that for 1 second because it was sort of the first question I had too. So Greg, if we start out with agreement between the two of you on at least the margins as to things that are illegal, right? The definitional line drawing question is still, I think, a challenge. And I'd be curious to hear each of your takes, and maybe we'll start with you, Professor Carl, and then hear from Ms. Lane. How would you, if someone said to you, right, as you know, a client, and says to you, well, where is that line? Well, what conceptual principle? I don't want to have to call you, pick up the phone and call you every single time I want to implement a new policy. What's the conceptual line that I should be using to know when I am and am not on the right side of the law?
And I actually like to assign my students, I did this year in my employment discrimination class, I wrote all of these different kinds of DEI stuff. And I said, which of these are legal and which aren't? They did not love me for doing that, but I think that's exactly the question. So I'm going to start with the employment context just because I know it best, but I think we could do analogies in education as well. We also have a new case that is helping on this, which is the Muldrow case, which defines how much harm is necessary in order to have an actionable case. And the way the Supreme Court handled the affirmative action stuff a while ago was to say that even in the remedial context, the harm to third parties could not be too severe. So you can never fire somebody from a job in order to put a person who's been the victim of discrimination in that job, even the actual victim. You can never do that. It's too much harm to the person who held the job. You can't lay people off with any attention to race because that's too much harm to the person. At one point, as a remedial order, the court said you could have a plan, a 50% plan where you're hiring one white person for one Black person, where it was established that this apprenticeship program had discriminated for 50 years against Black applicants. So there's this principle of like too much harm is unconstitutional. Muldrow looked at this question of what is too much harm in the Title VII context. And Justice Kagan wrote it. She said, well, some appreciable harm is necessary. So I would say the line is, and I wonder, I don't know if Ms. Lane will agree with this or not, but the line is focus on the amount of harm to a third party, right? So if you are saying, the most outrageous example you gave me to my mind was that people who have a certain skin color get 100%, $100,000 bonus. That is too much harm. That is too much harm. If you are saying we're going to have a networking event that's for people of color, I think that's a gray area, and I would counsel an employer who wanted to do something like that to say everyone's invited. Why say that only some people can come and not others? And I've seen that happen where people understand this is really a networking event that's mostly for minority lawyers or something like that, but everybody's invited and maybe you show up just to show your support or whatever, but you're not really there to, for the same reasons. So I think there's some gray area issues. I think there are some really clear issues. And I think that the touchstone is whether there is harm or exclusion of some people from that.
Yeah, so I think I agree with what you said, but I might even take a step back even before we get to the harm question and just the nature of classifying people. I think before we even can appreciate the harm, like the person who's not invited to the cocktail hour at the law firm or the person who's not invited to a student event or whatnot, Because I think that just by classifying, I agree that we're still operating in a gray area here, but just by classifying people and kind of putting labels on groups and people, does, I guess that does cause some harm. So maybe we're still talking about harm, but because it's just, to me, that is furthering kind of some levels of divisiveness in communities, so at law firms, in education institutions. And I think that for me, like I kind of compare these to like the affinity groups that we often hear about. I was in like Women in Law, for example, and so those are great those are great groups for how for people for people to bring in speakers or maybe have topics that they're talking about that are of particular interest. They're always very, very open to outsiders, to people who are for anyone to be able to come and participate, because I think if the goal is to kind of promote kind of more equality and have more robust conversations among diverse individuals, then the solution isn't to be classifying and siloing people off, it's to be bringing them together. So I guess in a way that now that I've talked myself around in a circle, I think maybe the harm framework is a helpful way to think about it, but I might even take a step back and say the classification itself can be harmful.
So, Ms. Slane, in your opening remarks, you emphasized that DEI is often just used as a proxy for racialism. And Professor Carl, you started by saying that we might have this definitional debate that no, DEI is actually just intellectual diversity. But to me, that seems like intentional goal shifting. So if it is, as you say, that it's really just intellectual diversity, then why was there so much outrage on behalf of DEI components about SFFA, and why the schools fight so hard to preserve their racial classifications?
Yeah, I think that's question sort of.
I think it's yes.
I didn't mean to say that DI is just about intellectual diversity, but it's about, perspectives in all kinds of ways and life experiences and all of that kind of thing. So it depends on how you read Students for Fair Admissions, I think, a lot. There's a way of reading it where it's a corrective on Grutter. It's not really that much more than that, saying that maybe some schools misunderstood what we meant in Grutter when we said it has to be individualized consideration, and there's no adding points, and there's no, kind of adding a benefit like that. And I think that schools felt very much like they were complying with the parameters that Grutter set. Now, I personally, having read the record really carefully in the Harvard case and reading Judge Burroughs' opinion, where she really hinted that she thought there was something really quite weird going on in terms of what the statistics showed about admission and discrimination against Asian Americans. But in the UNC case, there was really very little evidence that race was adding a benefit. It's something like 1.2%, maybe something like that. And so I think people were upset because they felt like the record did not support the conclusions that the court was pushing towards, was part of it. And I will say that after SFFA came down, because it is a little bit, it sort of speaks out of two sides and it's a little confusing. I mean, the number of hours and the amount of resources that were spent by colleges and universities and professional schools and graduate schools around the country trying to understand whether what they were doing, which they thought was already within the realm of Grutter, how to change it and what potential liability could there be. I mean, people were so confused, and it just people spent a lot of time trying to figure it out. And I think to this day, people don't really understand, what can they do and what can't they do, and what is their liability exposure. So I think there was a lot of upsetness about that. That's my take on what was the concern.
Yeah, I mean, I appreciate your question, because I do think that when we hear people talk about DEI, it's very abstract, which I can appreciate the scale. We're a little bit trying to focus in a bit, but you know, when we look at DEI, you know, there's always been, you know, groups organized, you know, people, like-minded people or people with similar, you know, interests or traits or whatnot have always kind of organized. And so like, what is different about like the new kind of DEI machines that we're seeing in institutions and, you know, workplaces? And I do think that they are, I mean, they have a mission to take action and to do, and it's not just kind of a passive like intellectual experience. It is something that, I mean, even looking at, I think, President Obama's executive orders on DEI, or his administration, you know, like set, you know, we want to recruit, we want to train, we want to promote, all action verbs. And so like, how do you do that? Well, you have to institute programs that are taking action and doing things. And so I think your question to me kind of hits on why the DEI machine apparatus as we've seen it today has become problematic, acknowledging that not everything under that is unconstitutional, but how it's used in an action is problematic.
This is mostly a question for Katie, but definitely a question for both of you. So the bulk of your argument focusing on, if I understood correctly, focusing on hinge on the idea that by using race as the only determining factor on the DEI practice, you overlook the differences in similarity across individuals. Also, as I understood, the equal protection clause essentially prohibited different treatment to people of otherwise similar situations. So would you say that a reform DEI or some other form of diversity program would implement a lot of different other criteria or consideration would somehow be more constitutional and by aiming at establishing how people are actually different?
Wow, big question. Solve DEI. Yeah, I mean, I do think that there are ways to go with kind of this, you know, having groups appreciating the fact that there are, you know, we have workplaces, university, you know, schools, I think that's where we've both been talking, that have, you know, lots of people with lots of different interests, and appreciating those, their, you know, different viewpoints and whatnot. And I'd say that, you know, we really, I think, want to get away from these like generalized assumptions about people and really kind of drill down into the individualized experience, which I think Professor Carl was talking about in context, you know, of like the student admission essay. And so like, how can we translate that kind of individualized attention programming to appreciate people's differences, but also, you know, not be making like these high level generalizations about individuals, you know, in society. I don't know if that directly answered your question, but
I was just thinking like, what if you implement many different factors, like not only race, but also,
okay.
let's say, gender and also socioeconomic background, the family structure they live in, etc. Like, what would that be more constitutional by establishing a genuinely different amount of people?
Yeah, well, so I guess I don't really know what that looks like. It kind of just feels like then all of a sudden we're just in a classroom setting where everyone's kind of talking about their individualized experiences. But yeah, I mean, I guess my problem is kind of the prohibited classification. So when we're, you know, dividing people up based on race, religion, sex, etc. Those but when you are understanding those based on somebody's like lived experiences, I think is the word that I think is the phrase that we hear a lot. Then that becomes, I think, less problematic because we're moving away again from the high level generalizations and we're moving into like the individual character traits. Now, what does a club look like that has, you know, it's like, then I think we're kind of in like a little bit of a intellectual exercise perhaps. So I don't know what that looks like, but I think that's the right direction, is moving more individual, focusing on the individual. How can, you know, in the workforce, how can we allow individuals with unique circumstances to succeed in this particular setting? How can we help them, you know, meet their, you know, perform well so they can get promoted? And those, but that's based on the individual, not again these like high level generalizations.
Is it right that the question is kind of capturing what I think you think, at least the Supreme Court said in Grutter, right? Which is race can be a factor among many as you look at a person.
Yeah, and at least our DEI office does all kinds of things. We have a first gen group that's for first generation college students. They do cool stuff around disability stuff. They do all kinds of things. And so I guess I would again, in my big concern, my big beef, I think is the idea that DEI equals race preference, which I reject that theory or that empirical statement, which isn't to say that it may not happen, as these good examples give, but in general, it's the two things are not synonymous. And the idea that DI is just focused on race, I think also is just not true in the world of what DI professionals think they're doing.
Sort of on the flip side of kind of trying to ultra individualize these criteria, the SFA decision kind of pointed out the invidiousness is stereotype, is tying classification to a stereotype. Is there any room in the joints, so to speak, if the stereotype is like, or rather the classification is the best proxy for the stereotype? I mean, the example that leaps to mind is I was in a class last week where someone remarked that there's value in having people of different national origins in the same class for the purpose of comparative law discussions, which is of course, true if you want to compare law, but it also deliberately discriminates, based on national origin. And so that would be kind of example where the stereotype is the best proxy. I'm just wondering how our frame of law would address that now.
Well, I'm going to reframe that question and I'll let the panelists ask, because I think what you're saying in some respects is if you're classifying, you're talking about national origin, so strict scrutiny, right? And it sort of feels like the question is that the least restrictive alternative, right? Is it a compelling interest, right? Is it a compelling interest to have the universe of students be from different backgrounds, different national origins? And if so, is that the least restrictive way to go about it? I think that's sort of what the question gets at. And so I guess we all know that if the answer to both questions is yes, then it passes strict scrutiny. I mean, we don't need to have a discussion about that, but I am curious from the panel standpoint, whether you think that that is what the court has in mind in SFFA. Is it even contemplating this kind of circumstance, or is this just kind of sort of a unicorn kind of circumstance that maybe is outside the rubric of what we're talking about?
Mr. Carl, do you wanna?
Well,
I'm like kind of a unicorn.
Yeah.
I think, well, there's a real question about how strict scrutiny now works after SFFA, because it basically didn't go through the whole, well, I guess it did a little compelling interest and everything. To me, the analogy I think of is, I jumped to Title VII and bona fide occupational qualification. So, and I was thinking, just to change your hypo a little bit, like what if you had a house where you had to speak German, right? At least when I was in college, we had like a French house and a German house, and you had to have a certain level of proficiency. And so people who came from Germany tended to always be able to be in the German house because they could speak German or whatever. And so, is that legitimate? And I would say probably yes. It made sense to say that people who were fluent in German should be the ones who were in the German house. In your case, it's sort of, like, would you assign particular spots for particular national origin students? It does seem to me like there might be a better way to handle that without having some sort of quotas based on who came from what country. So I would just use a rule of reasonableness, or perhaps it's a strict scrutiny standard to say there's a better way of doing that.
I would just say too, and again, I don't want to, as someone who does periodically have to decide strict scrutiny cases, it is, in my experience, rare that whatever is in front of me is the least restrictive. It's not never, but it's rare, right? Because if you put a bunch of minds in a room, they could probably come up with a different solution. And so, there may be compelling interests. And I deal with this more than you would think, because there's areas of law that you all don't think about, but that do raise strict scrutiny, most common of which is, can I close the courtroom when things are sensitive commercially? But it comes up a lot. And so it's rare, I would say, is the outcome. Yeah. Was that?
I'll take them.
Yeah.
Just, this has been so fun. Thank you all for coming. My question goes a bit toward the idea of implicit bias, right? So it seems like if you think that, I know that's been debated whether or not that's real, and if so, how important it is. If you think it's real, it seems like that would be a compelling reason to have sort of a race-based DEI system. Because if there's an implicit bias in society, then you think this would be a helpful corrective. And if it's not there, and if we kind of got rid of, if there was no implicit bias and we could just get to a colorblind society, that seems like a pretty strong factor weighing against any sort of race-based factor, because without it, it would just kind of eventually even out to zero. And so I guess you guys would be able to talk a little bit about implicit bias and kind of how you see that activity.
Go ahead.
Okay,
Yeah,
all
go
right.
ahead.
So I don't think I don't agree that you can say because there's implicit bias, therefore societal discrimination, therefore you can correct. Because the court has rejected that theory of societal discrimination. But I do think implicit bias exists, and I've written a very long article on the literature on that. So there is a lot of evidence that we all walk around with implicit bias. We have lots of implicit bias against our own identity groups, and it's very complicated how it all works out. And one of the things that DEI programs do is to try to do, at least our dean of inclusive education, who was a few weeks ago, was our dean for, I should say. She does implicit bias trainings, right? And agreed, there could be issues around how those are conducted, and if people are comfortable in the room and all that, that is definitely not a problem with the work that she does, the trainings that she does. But that is is not a race conscious way of addressing implicit bias. I think implicit bias should be addressed, but I think it should be addressed in ways that are legal and that aren't justifications for sort of shortcuts, like an unlevel playing field in order to compensate for what may or may not be going on in a particular situation.
Yeah, I think I agree with that. One thing that I think a lot of, like, when we're talking about kind of solving the problem, whether it's implicit biases or kind of like past, historical understandings of discrimination, if we get into, again, like this high level of generality, and I think it was in one of the Shaw cases, I think the court said, we can't, like, this is not a compelling interest if we're talking at this high of a level of generality, because then no legislator or no decision maker is ever going to be able to tailor, to basically achieve the narrowly tailored prong of what we're talking about. And so in that case, if we're talking about implicit biases for race, then I think that we get, so maybe we talk about a compelling interest for, there may be some interest in, I don't want to say putting thumb on the scale, but creating some sort of program or initiative that addresses that. But then the issue becomes, how do we narrowly tailor that to the problem when the problem has been defined so high, at such a high level? And so to me, that's kind of the, I don't want to weasel out of the first question about compelling interest, but if I can, then I think the real issue we get, the sticking point, is like, how do we make sure that whatever we're doing is actually addressing the issue when the issue's been defined so broadly?
And would you say that implicit bias training is unconstitutional? Well, let's say a public institution doing implicit bias training is unconstitutional.
Oh goodness. I think that, I don't have a strong answer on that. And I guess I think the reason for that is, it's been a really long time since I've done it. I can imagine ways to do it that would be unconstitutional.
There are lots of things, yes.
Of course. And so, but to say that every single implicit bias training or training that touches on implicit bias is automatically going to be unconstitutional, I don't think and that's partly because I'm not super familiar with all the different trainings.
And that's something that some of the president's executive orders say, is that, you're not allowed to use a federal contractor if the federal contractor has ever conducted a DEI training, or then you think, well, recently you were required to do DEI training. So does that mean that any federal contractor that was complying with the law a few years ago is now, uneligible for federal contracts? I think it's this throwing around of a term without defining it, without all of the things that we as lawyers really appreciate, like precision and definitions and care about matching allegations to facts. Those are the things that are just so concerning about this period that hopefully isn't going to continue to let go on, but for, right now, and something that everybody, I think, should oppose.
All right, oh, I'm sorry, go ahead, let's do this as the last question, go ahead.
Okay, thanks. So, a few months ago, we actually had Edward Bloom come speak to us, and someone asked, what is DEI? And he answered with a very colorful metaphor, regarding a bloated corpse and how it's like on the brink of exploding. And over the last few months, I've been trying to figure out what exactly that means. One recent critique I've heard of DEI is that when we're shifting from this sort of like generalizations about a certain demographic to a more individualized approach, it therefore places the burden on the applicant to sort of prove their worth by trauma dumping and explaining like deeply personal, like their origin story, which may take into account more than just race, but for specifically like socioeconomic class or gender-based violence, like things that ordinarily we are counseled not to bring up in an interview because it kind of like dampens the mood and puts your interviewer in a really weird spot. So I'm wondering for both of you, if you see that as an actual like possible side effect, and if so, does that undermine the purpose of DEI?
Well, I guess the flip side of that is that somebody experiences, the trauma, to use your word, is presumed because of a characteristic about that person. And so I think that, that generalization, that characterization, and that assumption is worse than having an individual. And I don't think it's necessarily proving your worth, but it's being able to articulate, if you have specific needs or interests or, I think needs and interests particularly, that, you are looking for in an institution or a workplace, and how that workplace can work with you, address those issues, or, find other people with common interests. And I think that individualization is a better solution than the generalization.
Yeah, I think this is a related issue that I worried about after I read SFFA, which is Robert saying in an essay, a student can explain, things that have to do with their racial identity. And I think we've already seen that students who have economic privilege and access to counselors and that kind of thing, people who are admissions, coaches, can benefit from that language in SFFA, but students who don't have all of those extra resources really don't have the opportunity to understand that. I know some students think that if I say anything about who I am, I'm violating the law or whatever. So that's when I talk about this confusion that the case has left and the impact that it has on admissions, I worry about all of those issues.
All right, I want to give our panelists a minute or so to wrap up. We're over time, but I do want to give them a chance. And so if anybody has anything they would want to say, Ms. Lane first.
Honestly, I think we've covered everything today. It's been great to be here. I appreciate the opportunity.
Yes, Carl?
Yeah, same. I appreciate the questions. I appreciate the civility of the debate, the great points that everybody here made, and thank you very much for inviting me.
All right, well, thank you, everybody. Appreciate it. Go down for a few questions.
Thank you.
Thanks.
Yeah.
Hope you enjoyed it.
You're gonna have